Welcome to Exploring AI Matters. This podcast series, previously known as Mind the Gap, Dialogues on Artificial Intelligence, will continue to appear in the ABA series to the extent that. In addition, all of the episodes, old and new, will now appear under our new podcast name, Exploring AI Matters. Thank you.
Welcome to this episode of our podcast, Mind the Gap, Dialogues on Artificial Intelligence. Given the innovative and creative applications of AI, its development and use raise important legal consideration, most notably in the areas of intellectual property and national security. Technologists introduce all manner of innovations, most of which disappear without much of an impact. The legal community seldom focuses on this froth until a technology begins to gain wide adoption and its use causes policy controversy. As AI evolves to increasingly perform innovative tasks, the idea that an AI-augmented machine can invent something useful when previously only humans could be inventors raises a number of complex issues, such as whether AI may be listed as an inventor on a patent. The U.S. Patent and Trademark Office, henceforward the USPTO, invited public comment in 2019 to gather information about the impact of AI technologies on intellectual property law and policy. The comments that the USPTO received expressed the consensus that existing laws and regulations did not require change to deal with AI. On the other hand, the National Security Commission on AI subsequently recommended that laws be changed to protect intellectual property rights in AIs and their outputs as a matter of U.S. national security. In this episode, we are fortunate to have one current and one former member of the USPTO staff involved in the preparation of those two critical reports. Our guests today are Rama Elluru and Christian Hannon. Rama Elluru, until quite recently, was an administrative patent judge on the Patent Trial and Appeal Board at the USPTO, and she is now at a nonprofit formed in October 2021 called the Special Competitive Studies Project, or SCSP, which develops recommendations to improve U.S. competitiveness in AI and other emerging technologies. Christian Hannon is a patent attorney in the USPTO's Office of Policy and International Affairs and a co-leader of the agency's AI Policy Working Group. Hello, I'm Mark Donner, a computer scientist.
Hello, I'm Roland Trope, a national security lawyer. We are your hosts for this episode of Mind the Gap, Dialogues on Artificial Intelligence.
In addition, we have two more hosts.
Hi, I'm Rama Adams, a national security lawyer.
And I am Charles Palmer, a computer scientist.
Each episode will be led by two of us, with the other two adding impromptu questions and comments as the spirit moves them. So, you are both experts in intellectual property, but when and why did you start to delve into legal issues involving AI?
Sure, I can start us off. So this is Chris Hannon. Just to make a small disclaimer here, I am preparing these remarks in my own personal behalf. These are not official agency remarks. I'm here in my personal capacity today, but I do thank the organizers and the podcast for having me and inviting me to speak. And I think, for me, getting involved in issues of artificial intelligence was really, to some extent, a product of the portfolio that I cover at my day job at the USPTO. And part of that is, I think I had a target on my back, so to speak, because I had my educational background was in comp sci, electrical engineering, computer engineering. So when the public momentum around AI and IP started to heat up, they, of course, said, well, Chris can do it because he's got the technical background. And of course, Chris couldn't do it without having done a whole host of legwork to really ramp up and get started. But I'll just leave that there and turn it over to my colleague, Rama.
Thanks, Chris. I too want to thank the organizer and hosts for including me today. And I make the same disclaimer. I'm here in my personal capacity, and nothing I say should be attributed to any former or current employers. So I actually also have a computer science background, have a BS in computer science, and my concentration was in something that's akin to AI. I don't know what it was called back then, but it was many generations of AI ago. And then my patent work concentrate on electrical engineering. The USPTO stood up the AI policy committee, I want to say in 2018, and I became a member of that committee, and I was just really interested in AI. It was clear to me that AI was going to be our future, is our future. AI is, it's ubiquitous to our everyday personal lives. You can find it in our phones. It's used to make our, recommendations to us on our social media platforms. You can find it in our cars. And so the more I learned, the more interested I became in the issues raised by AI and other emerging technologies. And, these issues span tech policy as well as legal. So that's how I got started.
So before we get deep into the discussion about AI, can either of you explain what qualifies an invention for patent protection under U.S. law?
Sure. I would say patent eligibility is a threshold for getting a patent. The subject matter of the invention has to be eligible for a patent. And there are 4 broad categories of subject matter that are eligible for a patent: processes, machines, manufacturers, and compositions of matter. As well. And also the Supreme created 3 broad judicial exceptions over many years. And these are natural phenomena, laws of nature, and abstract ideas. These subject matters aren't eligible for a patent. The invention also has to be new or novel. In essence, an invention can't be patented if it's certain public disclosures of the inventions have already been made. If the public already knows about the invention and the inventor is not adding to the public knowledge base, then a patent won't be granted. An invention also needs to be non-obvious. If it's not exactly the same or something that's already in the public domain, something the public already knows about, then which is referred to as a prior art, then it's considered novel. But for an invention to be patentable, the invention also must be a non-obvious improvement over the prior art. In simple terms, this means the invention sought to be patented would not have been obvious to a person of ordinary skill in the art to which a claimed invention pertains, and that's sort of a difficult a determination that's also made when granting a patent or not. In other words, the invention is compared to the prior art, and a determination is made whether the differences in the new invention would have been obvious. Lastly, a claimed invention also has to be useful in order for a patent to be granted on it. This means that the invention must have a useful purpose and some practical utility.
And I think I would just add that, for the listeners of the podcast that may be neophytes when it comes to patents, it's really, as Rama said, and anything that's new, useful, and non-obvious. And AI is bringing a host of questions to sort of where those lines will be drawn, especially around what is obvious, right? If we have this supreme knowledge that is capable of being bestowed by an AI, how does that affect the law of invention in that sense of what is inventive or what is not obvious? And also, how do you disclose those things, right? What does it take to actually teach the public how to use your patented invention when it comes to some new inventive machine, let's say, that you want to seek patent for? But I think, as Rama said, that's a pretty thorough and comprehensive overview of the sort of bare bones requirements for inventions.
Can I just ask a couple of clarifications on that may be helpful? How far-fetched can the usefulness be in the future? Because some things that people propose as AI inventions, they may not have reduced to actual practice when they submit the patent application. And what if they're thinking, well, when and if the technology arrives, this will be useful? Does the patent office make that kind of a determination as to how far out it has to be before it can be useful?
Usefulness gets a little tricky. So I think what you're really getting to is with that concept of, right, like sometimes you'll see these patents that are applied for that are, claiming teleportation or some, brain interface or something like this that is probably more in the realm of science fiction. And that has to do with this, the classical distinction with if you were going to need to, before we were in a first to file system, we were in a first to invent system in the US. So that meant that you had to prove to the office that you actually either had possession of your working invention or you had constructively reduced it to practice. And that meant you could write it down and explain it to someone and it would, hold up under scrutiny. So in those cases, really, that's more of a question of, are you actually in possession of your, can you write out your invention and adequately describe it to the patent examiner that's looking at it and convince that person that you are, in fact, at the time of filing now in possession of that invention. So as far as usefulness, the agency doesn't really police utility so much. There's a line of cases that goes back in decades ago that sort of scrutinizes pharmaceuticals and things of that nature. Think about the whole realm of any sort of material that's out there, and you can start to think, okay, well, is the PTO morality police? Where do we draw the line when it comes to what is useful, right? So we try not to play that game.
Yeah, what prompted me to ask that was that the U.S. Department of Commerce just recently requested comments on the imposition of export controls for certain brain-computer interfaces. So somebody coming up with, and they explicitly say that includes AI, which sounds pretty far-fetched to me, but obviously for somebody skilled in the field, it's not at all.
So hearkening back for a moment to your comments about one skilled in the art, Rama, when I was a young engineer early in my career and was filing one of my first patents or working on it, the patent attorney educated me by explaining that that the disclosure had to be sufficiently detailed and complete so that my friend Art is this wonderful engineer who can build anything given the instructions on how it works, but has not a single inventive or creative bone in his body. So basically, the stuff that goes into the patent disclosure has to be enough for Art to be able to recreate the invention. That was sort of that fellow Art has really sort of loomed large in my mind when I think about patents.
Yeah, the person of ordinary skill is a hypothetical legal person. And, part of the disclosure requirements is that you have to teach someone how to be able to make this stuff or do this stuff.
And one of the interesting things about AI, which really is, I think, comes to the crux of why this question is hard for us, is that one of the things we know about AIs is they can produce, let's say, solutions, answers, whatever it is, predictions that are demonstrably superior to anything else we can do, and yet we can't really quite explain how they did it. And, so in terms of telling Art how to do this, other than say, well, write the same software as I used and give it the same data I gave it, and now you've got it. That somehow seems very unsatisfying.
I mean, that's a great point, right? I mean, you can't just say apply AI and my invention is applying AI and coming out with this outcome, right? You have to sort of, again, teach how to make that AI or how to use that AI. So yeah, I think those are issues we're going to be grappling with. I think those are issues the Patent Office is going to be grappling with, is what is sufficient disclosure.
It's true also, isn't it, that many of the inventions offered in the area of AI don't even mention the word artificial intelligence in the disclosure. They refer to the electronics, they refer to the algorithms and software, but they don't use the words artificial intelligence. And maybe that's because the Supreme Court has been so negative over the last dozen years or so in narrowing what can be patented in the AI area, if I'm not mistaken.
Right. I think you're hitting on a broader point here that has sort of always been associated with software, and business methods to that end started to get the attention. And this goes back to what Rama was mentioning about the judicial exceptions to what is eligible for patent, because if you have plain as day in Section 101 of the Patent Act that it says, a machine, let's say, could actually be a qualifying invention, then, if a software runs on a computer and I claim that computer as part of the software, what's the problem, right? Well, the Supreme Court told us there's a problem because certain software is too abstract. And of course, extend that over to AI, and that's, I think, something we'll get to later, but that's sort of what we've heard from the public is that AI, if you can call it that, right, whatever that even means, because there's a whole pregnant definition question in there. But if you can figure out what you mean when you say AI, it's really, to some extent, it's just an extension of the software issues that the patent system has been facing for decades now.
Well, let's look at another sort of public assumption. It's a common assumption that a patent provides a patent owner with the right to practice and commercialize the invention covered by the patent. Rama, could you explain what rights a U.S. patent actually grants the patent owner and for how long?
Sure, that's not actually a precise assumption. A patent is a type of intellectual property that gives its owner the legal right to exclude others from making, using, or selling an invention for a limited period of years. And that time in the US, a patent provides 20 years of protection from the earliest filing date of the patent application. So a patent owner has the right to decide who may or may not use the patented invention for the period. So in other words, patent protection means that the invention can't be commercially made, used, distributed, imported, or sold by others without the patent owner's consent. But it is important to know that, a patent does not grant the patent owner any right to make their own invention. That's going to be determined by other things like other people's patents that might not be able, or that might not allow you to make or use your patent. It also is going to depend upon regulations, antitrust laws, FDA laws. That may restrict the ways in which a patent holder can use his or her invention.
So, for example, if I patent a new kind of lens for a camera, that doesn't mean I can put it on any camera that I want, because there may be patents on the cameras that I have to get license permission to use.
That's right, but you could exclude others from practicing that invention.
Right. Picking up on this theme of rights, Chris, what is the basic bargain between the government, the U.S. government in this instance, and the inventor when the USPTO grants the inventor a patent?
Sure. Yeah, no, I think that's the sort of the classic quid pro quo of the patent law, is that in exchange for the inventor's disclosure of precisely how to make and use that invention, in return, what you are granted by the government is a time-limited government-backed ability to actually exclude others from making, using, et cetera, your inventions. And so I think if there's any new tension today, at least beyond those we just spoke of on business methods, software, and all that sort of thing, I think one of the main issues now with AI is sort of, well, what does that even mean to be an inventor anymore, right? There's a lot of cases the world over right now that are grappling with this question of, well, what does it mean to invent? So if a machine creates something, does that satisfy that classical notion of, my inventive mind giving something to the public in exchange for time-limited rights? And I think it's a mistake to try to personify AI in that regard, because I think once you start to mistakenly personify AI, you start to think of it as maybe what we've always thought of as inventors, you and I, human beings, right, as inventors. And I think if you actually dig deeper, at least at a snapshot of like right now, you can start to see that these AIs, whatever they are, quote unquote, are actually just tools that are facilitating very advanced, sophisticated, as I think Mark put it, predictions, really. And we're very astute to leverage those predictions and have all kinds of neat things come out of them. But the second that you take it a bridge too far, in my opinion, that's when you start to call AI an inventor, maybe, and what are the ramifications of doing that? Then maybe we're outside of this classical quid pro quo, and maybe that makes the metaphor inapplicable today.
And if I'm right, the Patent Act defines inventor as an individual, and we don't normally refer to AI as an individual.
Well, we're fortunate in the U.S. that we have some strong statutory hooks, I think, to hang those types of arguments on. In other jurisdictions, less so.
Well, let me follow up on the point you were making. Back in August 2019, the USPTO issued a request for public comments to help it gather information on patent-related issues regarding AI inventions. Just a month earlier, 2 patent applications were filed with USPTO that identified an AI system called the Device for the Autonomous Bootstrapping of Unified Sentience, or as the acronym calls it, DALBUS, as the inventor. Chris, did the DALBUS application play any role in USPTO seeking comments shortly thereafter?
It's a great question, Roland. Thanks. And obviously, I'm not able to talk about the internal deliberations of the USPTO here, but I'll just say that for decades, the USPTO has been examining and granting patents on what many would consider fields of artificial intelligence. And so I think that point is quickly lost, that we have this really strong patent examiner workforce that is very adept and astute at examining these sophisticated technologies. They've been doing it for a long time. And I think to your question, though, really on the policy side of the house is where I sit. And we always, of course, try to keep abreast of these emerging technology issues. Obviously, the technology is not going to wait for us to figure out how to catch up to it. So we had been studying these issues for quite a time. And, our first, I think the really modern era data point would go back to January 2019, when we held a roundtable, number of panels covering all of the realm of IP. We dipped into some international perspectives. We did an economics panel. And so I think that's really the culmination of those latter requests for comments that we saw put out. It sort of can go back to those stakeholder comments that we heard at those particular roundtables back in January of 2019. And so the other work sort of flowed from that. And just to put that in perspective of DALBUS, I think that team, at least in the US, they first filed their applications around summer of 2019. So we'd already been sort of looking at these issues long before. And I think maybe, if anything, perhaps we might have stoked that inventorship issue at that time. And then you saw this flux of the DALBUS cases around the world thereafter.
Yeah, this is Charles, the other nerd. So I guess what really piqued my interest is when you said prediction, because one of our other interviewees talks about prediction machines. AI they're just prediction machines. The better the prediction, the better utility. And I wonder, can either of you think of any patents in the past that solely patented a process for coming up with a prediction? And if so, how would it be different if an AI is predicting what compound is going to be the best, to maintain the virility of a vaccine or whatever?
So I think that gets back to what Chris was mentioning earlier, that AI is really just an extension of some of the software algorithms that we've had in the past. I mean, I can't think of a specific software algorithm that used statistics, for example, to come up with predictions. But I think this is just a sophisticated way of doing that. So, but it does raise unique issues that we probably didn't have with our more simplistic algorithms.
And I'll just add, that nod to prediction machines, I think, is apt, because that's definitely one of the books that I read in my pursuit of trying to get up to speed on AI. That's an excellent book. I'd recommended Prediction Machines for sort of the economic side of analysis, and I'll look forward to that future episode of this podcast. But yeah, there are many, we've got over 10 million issued patents today, right? And that's not even including some of the very beginning historical patents, if you will, the X patents and all that. So a lot of patents that I'm sure there's a few that are actually processes or methods for generating predictions, but all of those will necessarily be a matter of law. They will be different and novel and bring something to the field with which they were there to define over the prior art, as that term, that everything that came before that particular process or method for making that prediction. And so if you can think about how many different ways there could be to paint a house, right? There could be that many different ways to predict how someone would pick a color to paint a house, right? So it's there's a vast spectrum, I think, for coming up with this inventiveness. And naming a precise patent number, I can't do that, but I think that there's definitely some that are out there, and that gets into a very interesting question of liability for infringing these particular patents that we may or may not touch on.
So many of the public comments that USPTO received indicated that no major changes were necessary in IP law to address issues raised by AI technologies. At a high level, could you summarize the key issues or themes that USPTO laid out in its October 2020 report following the comment period? Rama?
Sure. Maybe I can get it started, and then Rama can correct me. So I think one of the really overarching themes that we took away was the one that I made a nod to earlier, is you didn't define what AI is. So if we're going to talk about it with any sort of concrete, uniformity, we should probably at least define what it is that we're talking about. And so, I'm very sympathetic to that argument, because obviously there's so many different, tentacles flowing from the AI body there, that you really have to pin down what it is that you're trying to talk about to get there with any, especially when you're making policy, to make sure that good policy is being made. Another major theme was this question of where are we in the state of the art of artificial intelligence, right? Everyone can break it out into these two camps of, sort of the artificial general intelligence versus the more specific intelligence, narrow AI. So for listeners that may not be familiar, AGI is really just the singularity moment when computers know how to think and conceive of anything, and they'll create the problem and then solve it. It's not us giving the machine a problem and figuring out what it predicts the solution could be. So that was a general agreement, I think we saw in the comments, that we're not at that singularity moment quite yet. We're still sort of in this more narrow AI domain. And that's really important to think about, right? Because some people will advance things to the contrary at times. A third major takeaway that's in our report is that when it came down to what is the level of human engagement, there was this general agreement that we as human beings are necessarily required to operate many of the sophisticated algorithms that are out there. And that, I think, flows from that understanding that we're not at the AGI stage just quite yet. And most importantly, I think for the PTO, one of our major concluding points was that on balance, the majority of those that weighed in and sent us comments were really that the current architecture of our IP system was appropriately calibrated to handle the near term of sort of IP innovations that relate to AI. So the one question where things got a little bit more split was when you think about sort of the fuel of AI, if we can term it that, right? The data. So there's some out there that want to seek more protections for data, whatever, again, define that, whatever you're talking about there, because that's a loaded term that has many different meanings in many different policy contexts. But then if you could do that, maybe you need rights for data that are more robust than they currently are available under copyright law, let's say, or, even through trade secret protection. But Rama, I'm sure I'm forgetting something.
No, I think that's just right. I think that, overall, the public comments were the house isn't falling down, thankfully, but that we should look out on the horizon and see where we're going and what changes we might need to make in IP policy. The technology is evolving at a very rapid pace, faster than prior technologies. So it is something that we need to track and make sure that our IP regimes are on point to address the issues that are raised by these technologies. And as Chris pointed out, one of these is data. Data has always been important to us, but with AI and emerging technology, it's becoming even more critical. So that is one area that I think we need to track and make sure that we're in good shape with our IP laws and policies to address those issues.
So one of the core questions under discussion is whether AI may be identified as the inventor in a patent application or the author in a copyright application. Where did the USPTO come out in the Davos issue, and why?
Sure, I can lead us off on that one. So I think the way that the USPTO looked at this, and this is all publicly available on our website, so I'll just make a plug for that real quick. If you go to the main USPTO.gov site, you'll see links to the AI corner of our website, and then you click there, and you'll find all these reports we're talking about. You'll find some relevant legal decisions the office has made, and that was really how we handled this Davis case that was at the USPTO. In I believe it was April 2020, we actually issued a decision in the application to say, look, you have not completed perfectly your application. You have left off this critical component of who was the inventor, the human being that is the inventor. You have here listed Davis, and that's not a person. And so rather than modify the naming of a human being, they sort of pressed the issue with the agency, and the agency issued a final petition decision. And that petition decision really relies on the statutory constructs that we operate under at the USPTO. Section 101 says whoever invents, right? So we said, look at whoever. That's probably a person, right? Whoever, referring to a person. We see individual, right? As was mentioned in section, I think it was 115 that lists that as well. So replete throughout the statutory schema for invention, you're going to find these references that you can make strong arguments, I think, that this is a requirement that Congress has put there. So the flip side, of course, is, well, Congress didn't know about AI when they drafted these laws. So, okay, they wanted to promote innovation, and that's what you need to interpret those words to consider AI, again, whatever that means, falling underneath of those sort of classical human being type pronoun inferring words. So that's ultimately how we handled it. We looked at the statutory schema. We made our decision that this was really a question of humanity, and we said this Davis is not an inventor, and therefore, please either correct that or you're over on this. And so ultimately, they appealed that decision to the Eastern District of Virginia, which is maybe more infrequent path chosen for appeals from the USPTO. Usually, they will go to the Court of Appeals for the Federal Circuit, but there we already have our decision. From that court, and that court basically sided with the PTO and said, yeah, I agree. They did a pretty thorough statutory analysis here, and it's reasoned and based in the law. So yeah, we agree with the PTO. Davis, you can't, this is too great of a policy change. This would need to come from Congress type of thing if we're going to start to reinterpret this. And that's where we are today, in the US at least.
Rama?
So Chris, we've been hearing from some of the users of AI, that to think of AI as a tool, right? It's a sophisticated, innovative tool. So putting that kind of construct in the framework of the Davis decision, is one way for our listeners to think about this decision, that AI is a sophisticated tool that's used to create and innovate. But, as we sit here today, noting that things can change and emerge, the use of that tool is at the direction of, natural persons, right? The inventors. And that's sort of the framework or the lens with which a layperson could kind of understand what this decision means.
Yeah, absolutely. I think one way to think about it, right, by way of analogy at least, is right. There's CERN has their Large Hadron Collider, and they do all sorts of sophisticated experiments. And one day they exploded some things together, and they found that there's a particle, the Higgs boson, existed. Now, no one sat down and was like, the machine made that particle. It was like, no, we used the machine as a tool to find that. And maybe if that's too quantum physics, then maybe like the electron microscope, right? Like if I can see things and discover things through a tool that I otherwise could never have done, nobody thinks that the electron microscope should get the patent rights or whatever, right? It's the human that's behind that tool that ultimately appreciates it. And you see this a lot, I think, in a couple of use cases that have come up, right? Obviously, the pharmaceutical industry using these sort of like AI search algorithms to sort of figure out which combinations of materials may yield a viable drug component, or even in material science, same thing, looking at elemental structures of compounds and how will they interact to form, new and novel materials. And rather than having to, brute force all of those combinations, you just sort of get a top list of candidates from the machine, and then the human beings go in and they try to verify which is best, or if maybe I got a recommendation from that tool, but it wasn't really a viable candidate because of, some reason that came up in that practical application of sort of dividing that, whatever it was, a compound for a therapeutic drug or for, a new type of, cement or something, right? So I do think that's a really useful way to think about this.
Without going into USPTO's internal deliberations too much, did it also consider the fact that the Constitution grants Congress the power to create laws concerning patents and copyrights because it wants to create incentives for the creation of inventions, the creation of works of authorship. And it's not clear that a machine would receive any incentive whatsoever if granted a patent.
Yeah, I think I don't recall the text of the decision from Judge Brinkema that was the Eastern District of Virginia case, but I do remember maybe from the oral argument. I think I'm remembering that this came up, right? So obviously, Article 1, Clause 8, Section 8 of the U.S. Constitution. We're unique in the world that we have this innovative system shrined in our Constitution. So yeah, I think that's one way that the judiciary at least has thought about it, is that yes. Congress is in charge of making these policy determinations. If for some reason, a narrow, strict understanding that an individual can only be a human being, is that going to, confound the framers' intention here? If so, then maybe Congress needs to go and look at what we've done in our interpreting that law that's on the books today, because maybe it needs to change.
Well, comparing Congress to other countries, I note that a number of countries, South Africa and Australia, have address the issue of whether Dalbus can be the inventor of a patent application. Now, I'm going to leave South Africa out of the conversation because they don't really examine patents. An application is submitted and they just approve it. So that wasn't really a deliberative review. But a recent Australian court decision said you can identify under the Australian patent statute an inventor as an AI machine. Chris, Rama, what do you think are some of the key differences between these countries' laws and USPTO's consideration of the issue of who and what can be an inventor?
Yeah, Rama, you want to start us off?
Sure. I'm just going to reiterate what you said. Under our U.S. statutes and regulations, I think the question before the PTO and the Eastern District of Virginia was whether an AI can be named as an inventor. And under the current doctrines, I think that, that question was answered, that it has to be an individual, a human being. But, whether that's what, we should have going forward for policy reasons like incentives and, I think those are questions for Congress to address.
And Roland, the Australian and the South African case, I think, they're interesting cases because they're sort of, I think the legal team on Team Dalbus, these are, if I were them, I would view them as wins, I guess, from their legal team's perspective. And another thing, it's easy to dismiss the South Africa case because it was sort of like a formality almost that they got the rights granted there in South Africa. But if you take a step back, there's a thing called the Patent Cooperation Treaty, which is an international treaty that allows for single filing. And from that filing, all the WIPO member states, right, you have the possibility of perfecting your application in a national jurisdiction. And so they actually got WIPO to publish the PCT application, naming the machine Dalbus as the inventor on that PCT application. So that's an interesting thing because that's sort of, the implementer of the UN is behind WIPO, right? And so you have them making that determination that this is okay and this can fly out the door and land in all these different jurisdictions. But, in agreeing with Rama here, I think really what happened in Australia, it's again, they're looking at their law, they're interpreting what their statutory patent law says. And the judge in that case seemed to find some room in saying that really, we haven't defined inventor. And so this is a chance that we can really get out ahead of our international, colleagues and sort of take a stance on this that's contrarian in a way to what we've seen already. The European Patent Office took a determination. The UK's Intellectual Property Office took a particular determination, all citing in the same manner as the USPTO that you can't name a machine as an inventor under those patent acts. And so obviously it's different patent laws in every country. There's some sort of, I don't know, I won't call it harmony, but there's some uniformity in patent laws thanks to the WTO's TRIPS agreement, which governs sort of a floor for intellectual property rights. But that, of course, that was back, I believe, in 1994, and AI was not on the topics of conversation at that time for sort of how are we going to grant patent rights. And so maybe we're at a stage where the international community needs to get back together and start to think about this, if this is really, a right issue to discuss. Or maybe we're not even there yet. Maybe we're so squarely in this narrow AI world and we don't have to fear the AGI singularity upon us quite yet. And maybe that's not ripe yet.
Well, I read the Australian Judge Beach's judgment much the same way you did, that he read their patent law as not precluding a machine rather than requiring an individual. And he was very policy oriented. I should also note that when I checked recently, the Commissioner of Patents in Australia has taken the case up on appeal. So this is an open issue and we shouldn't be treating it as, the Australian position. It's one judge in the federal court in Australia. Rama, you were detailed for some time from USPTO to assist the National Security Commission on AI in its work in developing a report on AI, which it published in March 2021. Could you tell us what the Commission's objectives were and how the Commission went about its work, to the extent you're allowed to describe that?
Sure. Thanks for the question. Congress established the National Security Commission on AI in the 2019 National Defense Authorization Act. It was an independent federal commission with a mandate through October of this year to consider the methods and means necessary to advance the development of AI, machine learning, and associated technologies to comprehensively address U.S. national security. The commission was composed of 15 commissioners appointed by Congress and the executive branch with experience in industry, academia, and government. In November of 2019, we submitted our first interim report to Congress on the current state of AI for national security. And this report affirmed that the United States is in a strategic competition with AI at the center, and that the future of our national security and economy are at stake. So it called for new imagination, common purpose, and decisive action. And after that interim report, the Commission decided to release recommendations on a rolling basis throughout 2020. We delivered 3 memos, which culminated in a final report that we issued on March 1st of this year. The Commission worked in close collaboration with Congress, the White House, and executive departments and agencies to develop its assessments as well as its recommendations. We consulted a range of experts inside and outside of government on AI and its responsible adoption. And so the goal was to produce a comprehensive and enduring national approach to maintain its leadership, America's leadership and advantages in AI and other technologies. And the report considers where the U.S. stands on AI compared to its primary competitors and presents first steps the United States should take to defend, compete, and win in this new tech era.
Can we put a little finer point on it? Can you talk about the impact on the Commission's recommendations by its finding that I think it put in its executive summary that an adversary's potential use of AI, namely that defending against AI-capable adversaries operating at machine speeds without employing AI, is an invitation to disaster?
Yeah, the commission assessed that AI-enabled capabilities will be used as tools of first resort in this new era of conflict as our strategic competitors develop AI concepts and technologies for both military and nefarious use. There's also, because there are cheap and commercially available AI applications ranging from, let's say, deep fakes to drones, it's also becoming available to rogue states, terrorists, and criminals. So I would say the biggest danger is automatic response systems. The nature of threats and the time to respond to the threat is getting shorter and shorter. And these capabilities, they compress the amount of time for human decision making. So in the military context, for example, let's say a machine tells you that an attack is imminent. If you don't press this button in 5 seconds, you're going to die. What do? How do you get human decision making? How do you get human decision making involved into these systems? So, we need to have agreements on, maybe delayed responses. The automatic nature of these decisions need to be prescribed. They need to be agreed upon that that they're not a good thing, and that humans should be involved in decisions, and that the response time should be long enough to incorporate principled decisions, at least as a starting point. I'll point out that in our final report, we said, that China, Russia, and us should renounce automatic launching of nuclear weapons. And we shouldn't assume that there's one rule about human control or machine speed that should apply to all scenarios, because they raise, different questions and different issues in different contexts. It's important to determine where the types of errors machines make would be too consequential or might lead to escalation, and where humans should be, part of those decision-making systems.
Well, I noticed also in the report that it doesn't just describe China as developing AI at a rapid rate, but it focuses on how China has recently made changes in its patent strategies domestically and globally to position to try to become the global leader in AI. Could you describe some of the changes that China has made that the Commission was responding to, so this is more concrete for our listeners?
Yeah, unlike the US, China has recognized the importance of IP policies as a critical tool within its broader national strategies for emerging technologies. Until recently, it was in China's interest to have weak IP intellectual property rights to facilitate tech transfers, but China has changed directions. It's now focused on its tech capabilities and wants to strengthen its innovation systems as a key driver in its competitiveness. And one of the areas that it's focused on is intellectual property. China just issued guidelines to build a powerful IP rights country just last week. And this is the 14th five-year plan on IP. And it identifies goals that it wants to accomplish by 2025 with numerical benchmarks. And so some of these include doubling the number of high-value patents per 10,000 people to 12. And it wants to more than double the number of foreign patents granted annually. It wants to have a country where the value of the patent-intensive industries account for 13% of its GDP, and have annual trade and IP royalties of, I believe it's 350 billion yen. So while China is making it easier to acquire patent rights to inventions, I think the U.S. courts have severely restricted patent protection for computer implemented and biotech related inventions. And I think this, could have domestic harms as far as incentives for R&D, as well as international harms. The U.S. could potentially lose its IP leadership position and allow China to attract innovation to its borders, as well as influence other countries to adopt its technologies.
Didn't they also increase the penalties for patent infringement so that they're actually more severe than they are in the U.S.?
That's right. I think it's even working on increasing those patent infringement damages even more.
So given what you've described of China's patent strategy, could you explain the Commission's recommendations about what changes the U.S. should make in its patent laws in order to remain competitive with China in the field of AI?
Yeah, the Commission recommended that the United States recognize intellectual property policy as a national security priority, critical for preserving America's leadership in AI and emerging technologies. It didn't make specific recommendations on what that policy should be, but it did recommend that the U.S. needs to visit its IP laws, regulations, and regimes to make sure that they are up to date to address technologies of today. so that it can remain competitive. And the Commission reckoned that the Secretary of Commerce, in conjunction with the Director of the USPTO, should be charged with developing these policies, of course, in coordination with the other departments and agencies in the executive branch, and that should be elevated to the White House to decide which of these policy recommendations should be adopted into broader national security policies. And it also recommended that there should, it provided a non-exhaustive list of IP considerations that should be assessed as part of this policy formulation. We identified 10, although, again, it was a non-exhaustive list. And so one example was patent eligibility. The recommendation was to assess and articulate the impact of the current patent eligibility doctrine on innovation in AI and emerging technologies from an economic, trade, and national security policy perspective. Another one is IP protections for data, an issue that Chris identified. The recommendation was to assess the need for additional protections for data. And then also recommendations for combating IP theft, to assess additional executive branch efforts to counter IP theft threats, including actions in collaboration with our allies and partners. And another issue that we touched upon today, inventorship by AI, to assess the need for policies relating to AI-generated inventions and creations. And lastly, one of the IP considerations that we identified was the need to democratize innovation in our IP ecosystems, to expand the innovation base and make sure that everyone has access to innovation in the IP ecosystems through streamlining guidance, for example, for startups and startups seeking IP protection.
Rama, picking up on something you just were walking through on those recommendations, or circling back to the conversation we were having about data with Christian there. The commentators to the USPTO notice seem to generally agree that data was generally adequately protected under existing laws, whether that be trade secrets, copyright, licensing. And I was reading through the Commission's report. There was specific statements or concerns expressed about whether we had the right legal protections for data. And we've been hearing about how valuable data is in the context of AI innovation and technology, but the report seemed to put a national security lens on the protection of data. And it'd be great to sort of hear some more thoughts about how you guys were considering the value and importance of data and protecting it for American strategic value here.
Thanks, Amma. So, I think as AI and emerging technologies evolve even further, data is going to take on even a more critical role. China, for example, has an advantage in that it has a bigger population and has access to more data than we do, as well as other countries. So I think how we can leverage data is going to be very important to our tech competitiveness and innovation. So I think data is just going to take on even a more important role. And that's why the recommendation to make sure that we are poised to be able to leverage data and have proper incentives in place to make those data sets, whether they're organic or whether they're synthetic. And by synthetic, I mean made up data sets. So just to make sure that looking on the horizon, that we do have the protections in place to make sure that we have the incentives to create the data sets that will be necessary.
And I was going to pick up on that point, is that, thinking about, your listening audience and sort of if they want to get into AI and like, where should they focus their time and attention? So there's a book out there by Kai-Fu Lee that's called AI Superpowers. And it makes an interesting point relating to China and their data acquisition. And so, through the WeChat app or, whatever other applications that their citizens use on a daily basis, if you want to make a dentist appointment, or you want to eat dinner, or you want to go see a show, all of that's through an application. And so I think the author there, Kai-Fu Lee, is making the point that China has this rich wealth of data already available to them. And so, you can see it from sort of the European lens with their GDPR and sort of putting limitations on data. And then you've got China that's sort of the Wild West of data, where they've got every sort of aspect of your daily life because they've collected a data point on what you ate for dinner last Tuesday. And so where do we as the US, where do we want to fall, right? And how do we calibrate that so that we get it right? I think there's a Herculean task in defining what the data is going to be, and sort of only from there can you then get to that next question about, okay, well, how do we protect what we mean when we say data?
Yeah, and that's one of the, those are recommendations that the commission made also, that, yeah, sure, we need to, go forward with AI, but we also need to do it responsibly. We're not going to give up on our democratic values, our privacy, civil liberties, and civil rights. So while we do advance our tech capabilities, we do need to do it responsibly so that we protect our democratic values. So there's 2 chapters dedicated to responsible AI in the final report. Those are issues that we grappled with.
Before we wrap up, I'd be interested to know, since both of you have been discussing policy recommendations, what are each of you anticipating in the next year or two working on in the AI space with regards to pursuing those objectives?
So I'm at a new entity called the Special Competitive Studies Project, a nonprofit. And I will be looking at issues related to impacts in society, how AI is going to shape our futures and our societies and our democracy, and how we grapple with those issues, as well as intellectual policy issues.
Yeah, I think from the USPTO perspective, I think what, I would think that we're going to sort of stay chartered on really listening to what our stakeholders have to say, right? Are there really concrete issues out there that, we need to sort of focus on, and then how do we treat them? And we had some very exciting news the other day. We have our USPTO director nominee, Kathy Vidal, who's, I understand, has some familiarity with AI, may have even worked in AI. So I'm sure if anything, you could expect more from the PTO, I would imagine, if I'm reading the tea leaves correctly, on AI than less.
Well, on that note, I think it's clear that this conversation has opened up a broader horizon than I think we even realized when we started working on this session. And there's going to be a lot for us and our listeners to learn over the next year or two as we interview people and explore this space. This is a huge space and a very exciting one. I'd like to thank you both for your commitment of time and effort, and your thoughtful comments, and your sort of incredible insight into what's going on.
I want to echo that. Thank you both for your contributions and taking time to talk with us today.
We thank the Business Law section of the American Bar Association for their generous sponsorship of the production of this podcast. We welcome questions and comments from listeners. Send email to comments@mindthegapdialogues.com. We read all comments and questions, and we'll try to respond in the letters section of a future episode. If you are writing about a particular episode, please do mention the specific episode number. Please also do include pronunciation tips to help us properly say your name when we reply in a subsequent episode. See you next time on Mind the Gap, Dialogues on AI.
Thank you for listening to the ABA Business Law Section's podcast series, To the Extent That. The section offers a robust collection of content. To explore more about this topic, or to learn about joining the section, visit ambar.org/bizlaw. That's BIZLAW.